A Medicare set-aside is also a medical damages report. We outline what do you got, what do you need, why do you need it, how often, how long, and how much. What's the medical condition, what's the medical care, why the medical care is needed, how often, how long it's needed, how much it's going to cost. But there's an additional step in a Medicare set-aside report. What we also need to do is identify what medical care is covered and not covered under Medicare. There's a law out there, there's a federal law out there called the Medicare Secondary Payer Act. And that law says that whenever a case is settled, and in that settlement the individuals on Medicare are expected to be on Medicare in the future, and in that settlement there's money for future medical care, we have to protect Medicare's interest. How do we protect Medicare's interest? We do that through a Medicare set-aside report. A workers' compensation case, a liability case, doesn't matter. The federal law says we have to protect Medicare's interest. How we protect Medicare's interest is through a Medicare set-aside report. We review the records, we outline what the patterns of care are, what the physicians recommend, we figure out what the billing codes are, what the costs are, and then we identify what's covered and not covered under Medicare. That's going to help you walk into the settlement to create the settlement documents earmarking what future medical care is covered under Medicare and what's not covered under Medicare. It's a medical damages report, but why you need it is totally different from a life care plan and a medical cost projection. Life care plans, expert witness testimony. Medical cost projections, snapshots of medical damages at any point in time of the case. A Medicare set-aside is to protect Medicare's interest according to the federal law. According to the Medicare Secondary Payer Act, which is a federal law, we have to take Medicare's interest into consideration when we're settling any case, not just a workers' comp case, it's any case. That includes personal injury, med mal, liability. Why would you use a Medicare set-aside? Two things. One, to protect Medicare's interest. The second is to be able to protect your client. If you're a plaintiff attorney, you want to protect your client. You want to be able to outline future medical care, figure out the costs that go with it, and earmark whether it's covered and not covered under Medicare. So as a plaintiff attorney, you have a due diligence to your client to protect your client to then protect their Medicare benefits. I've seen on cases where the plaintiff attorney has not done a Medicare set-aside or not considered Medicare's interest. Sometimes we will not do a full-blown Medicare set-aside report, but we will do consulting with plaintiff attorneys on particular cases as to whether or not Medicare's interest should be protected on the case. Plaintiff attorneys will call and consult with us, give us the specifics of the case. We bring our decades of experience to the table and then be able to guide the plaintiff attorney whether or not a full-blown Medicare set-aside report should be completed. We have unfortunately seen situations where Medicare set-aside reports or Medicare's interest wasn't considered, was not documented in the settlement documents. Months, years go down the road, and what happens is their client ends up on the short end of the stick. Because Medicare's interest wasn't considered in that settlement, their Medicare benefits are now frozen, and so they're not able to get access to medical care because their Medicare benefits have frozen. On the flip side of that, we also work with defense attorneys, again, consulting on cases. We bring decades of knowledge, skills, training, and experience to the table to be able to talk to defense attorneys. They want to protect their client. So that could be the insurance company, that could be the employer. What happens on that side is if Medicare's interest isn't considered, Medicare could come after the insurance company or the employer and could have huge penalties and fines on the insurance carriers and the employers if Medicare's interest isn't considered on that side. What we find with Medicare set-aside reports, these are tools that are used after the settlement. So having a Medicare set-aside completed for your client is going to be a tool that they're going to use after the settlement. It's a guideline of what kind of medical care they're going to need, what's covered and not covered under Medicare. An interesting fact is once cases are settled, Medicare set-asides, the majority, like 95-97% of Medicare set-aside reports are what we call self-administered. That means the client takes their own money into their own hands and they manage that money. So what we have to make sure is that you're protected as an attorney, plaintiff or defense, it doesn't matter. You're protected that there's a formal report, there's formal documentation, because 95-97% of the cases that settled, the client is going to be handling their money. So if they goof up, that could come back to bite you in the future. You could also be fined by Medicare. You could also have a due diligence issue and open yourself up for liability. So why should you bring FIG in to do a Medicare set-aside? Number one, to protect Medicare's interest under the federal law. Number two, to make sure that there's an accurate projection of future medical care, making sure that the case is not overfunded or underfunded. We earmark what's covered under Medicare. And number three, to protect your firm's name in a due diligence. This is going to be when you're nearing mediation or into a jury trial. Medicare set-aside reports will typically come after a cost projection, after a life care plan. It's very, very helpful for us to have a cost projection or a life care plan, if it was done, to bring that to the table for us to be able to complete the Medicare set-aside. We don't have to have the cost projection or life care plan, but we will ask for one. Completing the Medicare set-aside should be around the time of the mediation, before, not after, and the same thing with the jury trial. Medicare set-asides can also be completed prior to trial or even right after trial. Sometimes we wait for the jury awards and then we determine what the award is and then identify future medical care covered under Medicare at that point. So when you bring FIG to the table for a Medicare set-aside, it's going to be towards the end of the case when you're gearing up for mediation or you're gearing up for trial. Medicare set-asides are typically used as a consultant behind the scenes. Very rarely do we come in as expert witnesses on a Medicare set-aside. It's not something you really want in front of the judge and the jury. It's what's covered and not covered under Medicare. You want the life care plan in front of the jury, not the Medicare set-aside, because at that point it's a collateral resource and you could run the risk of the judge determining an offset of what's covered and not covered under Medicare. So it's typically something that's done behind the scenes around the time of mediation or jury trial. We consider a Medicare set-aside report, it's a medical damages report, but it's very much what we call an administrative tool. For one thing, protecting Medicare's interest is required by the federal law, the Medicare Secondary Payer Act. How we consider or how we protect Medicare's interest is open for interpretation. We have several guidelines and memos that are put out by Medicare that tell us what they think we should do for workers' compensation cases. We understand that there are memos and guidelines coming down the pipe on liability cases, but as of now, no memos and guidelines have been published to talk about considering Medicare's interest in liability. So what we do is a good faith effort by creating an administrative document. A document that's called a Medicare set-aside report outlines future medical care, the cost, whether or not it's covered under Medicare. This Medicare set-aside report is going to follow the case even after settlement or even after jury award. What happens is 95 to 97% of the cases that settle with a Medicare set-aside report, the client ends up managing that money. So what happens is let's say hypothetically the case settles for $500,000. We come in, we look at the medical records, we identify the medical care, the costs that go with it. And so we recommend $150,000 of the $500,000 be placed in a bank account. It's earmarked for Medicare. The client puts the $150,000 into a separate bank account. That money is earmarked specifically for medical care that's covered by Medicare related to the accident. So what happens is before the individual hands over their Medicare card for care related to the injury, they have to spend down that $150,000. 95 to 97% of folks are managing that $150,000 by themselves. So that puts you, the attorney, at risk if they don't properly manage that money. So we come in, FIG comes in, we complete an accurate Medicare set-aside report. We're also available to talk to the client, to talk to the individual, explain to them what a Medicare set-aside is, how you put that money in the bank, how you're supposed to spend that money, and how you're supposed to keep detailed records and bank statements that if you were ever audited by Medicare, we come in and we explain that information to the client. So what we're doing is we're doing our due diligence to help protect your liability. So the reasons why you would want a Medicare set-aside on your particular case is to outline future medical care that's covered under Medicare to ensure proper funding on that case, protect Medicare's interest, which is a federal law, and then also to protect your firm.